At 11:47 at night in Washington, a federal judge reached for the enforcement lever of the United States government and aimed it at Donald Trump. This is not normal. Washington, District of Columbia, 11:47 Eastern Time. A federal court enforcement order moves through a secure transmission channel to the United States Marshals Service. Within minutes, confirmation appears on the electronic docket. A sitting federal judge has directed federal law enforcement officers to ensure compliance with a binding court mandate involving Donald Trump. Pause there, because this is not a routine filing. It is not a scheduling order. It is not symbolic language crafted for headlines. It is the activation of judicial enforcement power at the federal level. The signed document invokes the court's inherent authority under Article 3 of the United States Constitution. The judge determined that a prior lawful order was not fully complied with. Based on that finding, the court triggered its contempt-linked enforcement authority and directed the United States Marshals Service to execute the mandate. Donald Trump responded quickly. He characterized the directive as an unlawful command. He stated publicly that he would refuse compliance while pursuing further legal challenge. Let that land properly. A federal judge says comply. A former president says no. At that moment, the dynamic shifts from litigation to institutional confrontation. Here is where you need to understand the context. The full background was not explained in the initial filing. There was no extended narrative attached. Only enforcement language, only operative instructions. The trigger was procedural. A federal subpoena had been issued under established authority. A compliance deadline expired. A review hearing took place. The court concluded that compliance was incomplete. That finding matters because it unlocks something powerful, the enforcement arm of the federal judiciary. Immediately after the finding, the judge issued a directive instructing the United States Marshals Service to ensure execution of the court's order. Shortly thereafter, the clerk's office confirmed the status. The order is effective immediately unless stayed by a higher court. That sentence is the fulcrum, unless stayed. The legal mechanism now in motion is the enforcement authority tied to contempt power. Federal courts possess inherent authority to compel obedience to lawful orders. When voluntary compliance fails, enforcement becomes available. The United States Marshals Service, though administratively housed within the Department of Justice, carries a statutory obligation to execute lawful judicial directives. This is where the institutional lines intersect. At the center stands the judicial branch, specifically an Article 3 federal judge with lifetime tenure. That office carries concrete authority to issue binding rulings, to compel production of documents or testimony, to determine non-compliance, and to direct federal officers to enforce orders. This is not abstract constitutional theory. These are operational powers. And here is the structural hinge. If the judge withdraws the order, the process stops. If a federal appellate court issues an emergency stay, the enforcement pathway freezes. If neither happens, the mechanism continues forward. That conditional framework is everything. Now step back and widen the lens. What makes this different from ordinary high-profile litigation is not the name involved. It is the scale of power engaged. This is not campaign rhetoric, not cable news argument. It is a collision point between federal judicial authority and the institutional gravity of a former president of the United States. Judicial power is now pressing into territory once occupied by the apex of executive authority. That is a constitutional stress point. There is no broad constitutional immunity shielding former presidents from lawful court orders. Yet direct enforcement through the United States Marshals Service against a former chief executive, particularly in the face of explicit refusal, sits at the outer edge of modern precedent. Let me say that carefully. The system is operating within its formal authorities, but it is operating under maximum institutional tension. This is where the event stops being about one individual and starts being about the architecture of federal power. The judiciary has asserted compliance authority. The former president has rejected it as unlawful. The enforcement arm of the executive branch is positioned in between. The system is not debating. The system is executing. And when execution replaces argument, the consequences are no longer theoretical. They are procedural, immediate, and capable of forcing other branches to respond in real time. Because once enforcement authority is activated at 11:47 Eastern Time, the next question is unavoidable. What happens if the stay does not come in time? So what actually happened between the moment the subpoena was issued and the moment the enforcement lever was pulled? Let us walk it cleanly, step by step. Because in Washington, escalation rarely explodes. It tightens. Step 1, a federal court issued a subpoena under established federal authority. Lawful, structured, within jurisdiction. Step 2, the compliance deadline expired. No drama yet. Deadlines pass all the time. Extensions get negotiated, motions get filed. But here, according to court findings, full compliance did not occur. Step 3, a verification hearing. The court examined representations, submissions, and responses. This is where the temperature begins to rise. Because once the judge formally reviews compliance, the question shifts from negotiation to adjudication. Step 4, the court concluded that compliance was incomplete. That finding matters more than any headline. It is the hinge point. Because once a federal judge makes a determination of noncompliance, the toolbox changes. Step 5, the enforcement order was signed and transmitted to the United States Marshals Service. This is where the system moves from request to command, and here is the institutional architecture behind it. The federal court invoked its inherent enforcement authority. That authority is rooted in Article 3 of the United States Constitution. It includes the power to compel obedience to lawful orders. It includes contempt authority. It includes the capacity to direct federal officers to execute mandates. The United States Marshals Service does not act independently in this context. It executes lawful court directives as a statutory obligation. The Department of Justice confirmed receipt of the order and acknowledged that obligation. 3 branches are now synchronized around a single procedural axis. Let that settle in. The judiciary issues the command. The executive branch enforces it. The legislative branch watches. This is checks and balances in motion, not in theory, in execution. And here is where the doors begin to close. The voluntary compliance window is closed. That phase is over. The informal negotiation channel has narrowed dramatically. Once enforcement is signed, informal resolution becomes structurally harder. The request for reconsideration at the district court level is nearly exhausted once the finding of noncompliance is entered and enforcement authority is activated. Only one major door remains fully open, an emergency motion to the federal appellate court seeking a stay. Unless that stay is granted, the enforcement pathway continues. This is not symbolic pressure. It is a countdown embedded in procedure. Now look at the institutional response web. The White House issued a neutral statement emphasizing respect for judicial independence. No endorsement, no criticism. That restraint matters. It signals institutional distance. The Department of Justice confirmed the legal obligation of the United States Marshals Service to execute lawful judicial orders. No deviation, no reinterpretation. Congressional leadership indicated they are monitoring developments but will not intervene directly, citing separation of powers constraints. This is where the narrative shifts from individuals to structure. No branch is openly breaking formation. Each is staying within its lane. And yet the lanes are converging. The legal limit under stress is precise. Does a public declaration that an order is an unlawful command alter the duty to comply if no appellate court has stayed the order? Under standard doctrine, it does not. But this is not a standard exposure. There is no immediate answer beyond process. And process takes time. Meanwhile, enforcement authority remains live. This is not about rhetoric. It is about which branch defines legality in real time. Now we approach the constitutional boundary. The power being pushed to its limit is judicial enforcement authority when directed at a former president of the United States. Not a cabinet official, not a corporate executive, a former chief executive. There is no constitutional provision granting former presidents absolute immunity from lawful court orders. That is clear. But direct enforcement involving the United States Marshals Service against a former president who has publicly refused compliance is rare terrain. Modern precedent at this level is limited and highly contextual. That absence of clear precedent does not invalidate the authority, but it amplifies the stakes. Here is the unanswered question hanging over the system. Will the appellate court, or ultimately the Supreme Court of the United States, intervene before enforcement proceeds further? Because timing is everything. And that brings us to what we are watching now. First, the emergency motion for a stay. If filed, it will likely argue irreparable harm and challenge the scope or validity of the enforcement order. Second, the response window from the appellate court. In high urgency cases, responses can come within 24 to 48 hours. Sometimes faster, sometimes slower. That uncertainty matters. Third confirmation of operational readiness from the United States Marshals Service. They do not publicize tactical details, but acknowledgement of readiness signals that enforcement is not theoretical. Overlay this with the additional compliance deadline reportedly set at 48 hours from issuance of the enforcement order. If no stay is granted before that deadline expires, escalation becomes procedural, not rhetorical. The clock does not argue. It advances. And this is where the system feels the strain. No tanks in the streets, no emergency proclamations. But institutional pressure at maximum load. The judiciary has asserted authority. The executive enforcement arm is positioned to act. The legislative branch remains in oversight posture. The subject of the order refuses compliance, pending further review. Everything remains inside the formal framework. Yet the framework is under stress, not collapsing, but stretched. The next filing, the next order, the next response from the appellate bench. Any one of these could recalibrate the balance instantly. Until then, the enforcement order stands, the deadline approaches, and the separation of powers is being tested not in theory, but in real operational sequence. The system is running hot. And the margin for institutional miscalculation is narrowing. So where does this go from here? When institutional pressure rises to this level, the noise can be distracting. The only way to track it is through indicators, concrete signals, measurable shifts. There are 6. First, whether the federal appellate court issues a stay. Not commentary, not speculation, a formal order. If a stay is granted, enforcement pauses immediately. If it is denied, the enforcement authority remains active. That single decision will tell us whether the judiciary above the trial level believes immediate intervention is warranted. Second, the scope of modification if the order is adjusted. An appellate court could narrow the enforcement language without vacating it. That would signal caution, not rejection. Watch the wording carefully. In moments like this, a single paragraph can recalibrate the balance between branches. Third, detailed clarification from the Department of Justice. So far, the acknowledgement has been procedural. If the department elaborates on execution parameters, timing, or interpretive boundaries, that will reveal how the executive branch is navigating its dual obligations, loyalty to lawful court orders, and sensitivity to the gravity of the target. Fourth, whether Congress initiates oversight hearings. Leadership has stated it is monitoring developments. If formal hearings are announced, that introduces a legislative layer into what is currently a judicial-executive interaction. That would widen the field. Fifth, the scope of executive privilege arguments invoked. If filings expand the claim that certain materials are shielded by residual presidential authority, the dispute shifts from compliance mechanics to constitutional doctrine. Sixth, any sealed compliance arrangement. A negotiated filing under seal could indicate partial resolution behind the scenes. That would not eliminate tension, but it would change the trajectory. These 6 signals will define the slope. Now consider the 3 possible scenarios. Scenario 1, institutional de-escalation. The appellate court grants a temporary stay. Enforcement pauses. The dispute transitions into structured briefing and argument. The temperature drops. The confrontation moves from operational readiness to legal interpretation. The system absorbs the shock through its normal channels. This outcome would not erase the tension, but it would contain it. Scenario 2, procedural escalation. No stay is granted. The United States Marshals Service proceeds with limited enforcement measures strictly within the scope of the order. No theatrics, no overreach, just execution of mandate. At that point, emergency petitions would likely be directed swiftly to the Supreme Court of the United States. This is where pace accelerates. Because once enforcement action is underway, the timeline compresses. Higher courts are forced to decide under pressure. Scenario 3, deeper constitutional confrontation. Litigation expands, privilege arguments intensify, congressional oversight increases. The executive branch faces sustained cross-pressure from both judicial mandates and political scrutiny. The dispute becomes multi-layered, judicial, executive, legislative, all at once. That is the scenario where structural friction grows. Notice what all 3 have in common. None involve collapse. All involve institutional strain. Now widen the lens further. 5 parallel impact axes are already visible, legal. This episode could clarify the outer boundary of judicial enforcement authority as applied to a former president. The resulting opinions, if issued, would shape future disputes far beyond this one. National security, If the subpoenaed materials involve sensitive information, the courts will have to balance enforcement with protection protocols. Even the handling process carries weight. Political polarization around separation of powers will intensify. Supporters and critics will interpret each procedural move through partisan frames. That does not change the law, but it changes the environment in which law operates. Electoral, the confrontation may influence campaign rhetoric and public perception. It does not alter ballot mechanisms, but it reshapes narrative terrain. Geopolitical. International observers watch moments like this closely, not for spectacle, for evidence of whether the United States system self-corrects through law rather than force. Here is where the gravity drops again. At 11:47 Eastern Time, a federal enforcement mechanism was activated against a former president of the United States. The order remains in effect unless stayed. The compliance clock is running. No branch has stepped outside its formal authority, yet each branch is feeling the pressure generated by the others. And so we arrive at the deeper constitutional question. Where exactly does presidential power end once the term ends? How much strain can checks and balances absorb before the Supreme Court of the United States must intervene to define the boundary? And perhaps the most consequential question of all, does the current legal framework possess enough internal elasticity to resolve this confrontation through procedure alone, or are we witnessing the outer edge of how far institutional self-correction can stretch?